Good afternoon, ladies and gentlemen. Thank you for joining us today for a really interesting discussion on property law, different marriage regimes, and property, and how what their effects are on inheritance. And this is presented by attorney Vicky Rotor-Hilado, who has actually we haven't seen for a while here, who first spoke about this perhaps in 2017 and again in 2019. And so after the pandemic, we're very happy to have her here again. And judging from the turnout today, I think a lot of people are really interested in figuring out what's theirs, what's hers, what's hers, what's hers. Okay. So let me introduce Attorney Rotor. Vicky is a graduate of the Ateneo Law School. She graduated in 1985 with a Bachelor of Law degree, laws, I should say. She graduated third in her class and placed fifth in bar examinations of the same year. She began working for the law firm Angara, Abello, Concepcion, Regala, and Cruz, Acra Law, in other words, beginning in 1986 until 1989, resigning as a newly minted senior associate in the corporate special projects department. While simultaneously being a solo practitioner, she was a part-time consultant to Acra Law in 2000 until the pandemic, attending to several projects in the firm, including electronic data conversion. She is currently a solo practitioner specializing in estate planning, estate settlement, and real property transactions. She's the author of several books, which you'll find there in the corner if you'd like to purchase, including A Well-Ordered Estate, Heirs of Their Shares, in addition to the Laws for Life 1 and 2 series that she co-authored with attorney Gianna Reyes Montinola, and Retooling Life Insurance, Resolving Succession, Inheritance, and Partition Problems through life insurance. So without further ado, I bring you attorney Vicky Rotor-Hilado.
Good afternoon. Can you hear me well? Thank you for attending this short talk on what is yours, what is mine, what is ours. So normally when I talk to my husband, I always ask, what is mine? What is mine? What is mine? So the whole point of this lecture is to understand the different property regimes which govern a marriage. Now, may I see a raise of hands to those who knew that there was a marital regime before you got married? Did anybody know? Can you raise your hands? Did you know that the minute you said I do, there was a marital regime that was going to govern the way you manage your properties and dispose and own? Okay, now, when a man and woman marry, there is a contract which is entered into. It's either entered into in the name by way of a prenup, or which the law calls also a marriage settlement, or if you don't enter into one consciously before you marry, the law imposes the regime that will govern the way you manage your properties while you are married, until you die or until your marriage is dissolved. So you either it's a contract entered into or imposed by law in order to establish the conditions of their marital partnership with respect to their present and future property. This contract entered into by the parties or the law governs the marital property regime. Under the law, the first rank of a marital regime would be a prenup. That's the first choice given to you. You're given that option. If you don't do a prenup and you are married from August 3, 1988 thereafter, then you are governed by what we refer to as the absolute community. On the other hand, if you married before August 3, 1988, and you did not have a prenup, you are governed by the conjugal partnership of gains. That's the marital regime I was under because I got married in 1987. So either from the gauge of the people that are here, most of you were either married prior to 1988 and are governed by the conjugal partnership of gains. But even if you were married prior to 1988, your children would probably be governed by absolute community unless they enter into a prenup. The fourth choice is a choice which is not normally conducive to a happy marriage, which is the complete separation of property. It's not frequently chosen, but I have had several clients that have chosen complete separation for various reasons. Why is there a need to distinguish? The exclusive owner of a property has the right to sell, to mortgage, encumber, to possess, to administer, and enjoy without securing the consent of the other party because that property is theirs alone. So I don't know if you will notice this. Some of you purchase property. Many times the buyer or the seller will ask you to get spousal consent. So I always tell them this property is either separate property of the seller, and so the consent of the spouse is not necessary. But to play safe, they always ask for spousal consent, maybe because they don't know the law, or second, they just do it as a sort of insurance. Otherwise, if the property is co-owned, you need the consent of the other party in order to dispose. Otherwise, your sale or anything else you do will be void. Why is there a need to distinguish? When one of the spouses dies, property which is exclusively owned by the surviving spouse does not form part of the estate of the deceased person. It is not subject to estate tax, and more importantly, you don't have to share it with your children if you are the surviving spouse, with respect only to separate property. When a spouse dies, property which is exclusively owned by the deceased spouse, 100% of the exclusive property and 1/2 of the communal property goes to the estate. That is what is subject to estate tax, and that is what is divided. So if I own 100% of something because it's exclusively mine, and I share with my husband 50% of another thing, if I die, my estate is the whole 100% of what I own plus 50% of what I own with my husband. Now, you're saying, so why is that important? I'll illustrate to you. Let us give this example of a wife who has exclusive property valued at 100 million. Her husband exclusively owns property valued at 50 million. Together, the two of them, while they were married, they worked, they bought stuff, and together, they put together 20 million. Okay? So you can see the common owned property is 20 million, the wife's exclusive property is 100 million, and the husband's exclusive property is 50. If the husband dies, what is the estate you are dividing? If the husband dies, it's 50 million plus 10 million. That's his estate. That is what is divided among the children and the surviving spouse. 60 million. So you can see 100% of what the husband owns because he died, and 50% of what he owns with his spouse. On the other hand, if the one who dies is the wife, the estate is 100 million plus 10 million or 110 million. So you can see that the size of the estate is considerable. And the children will want the person who died to have more. Obviously, because they will get a bigger share. So if it's dividing 60 million, they will divide 60 million versus dividing 110 million. You can see where the difference lies. Now, a lot of people think that if you're married, everything across the board is one half. I have lawyers coming up to me and saying, okay, this is the estate, my wife owns this, I get one half automatically, and I get another half from the other half, and then I split still whatever's left behind. But this is wrong. Let us give this example where it's the other way around. You have a wife who only has 10 million, that's her exclusive property. You have a husband whose exclusive property is 50, and they have common properties worth 110 million. So when the husband dies, you can see here that his estate to be divided among his children and his wife is 105 million. On the other hand, if it's the wife that dies, her estate is only 65 million. I had a relative who knew that her husband's exclusive property were all inherited. But because of the way they were documented as sales rather as an inheritance. What happened is, she claimed that everything was across the board conjugal. So she demanded half of everything, even if it came from the ancestors of the husband. It was because the transfers to him were not documented properly. They were documented as if they bought it, rather they inherited it. And why did they do that? Because prior to 2018, the donor's tax had a maximum of 15%, and the estate tax had a maximum of 20%. But if you did a sale, it was 6% capital gains. So without thinking, these people went for the lower tax rate. So they said, oh, let's just pretend we bought it from my dad. But because the tax was only 6. But if it was a donation of the father to the child, it would have been 15. And if the father died and then the child inherited it, it would have been 20. So they only were conscious of the tax. But in the process of pretending it was a sale, where they only paid 6%, the child lost 50% of her inheritance. So it's a matter of 6%, but you lose 50%. Because as a general rule, Filipinos don't like to pay tax. And so they're always looking for the cheapest way to do something, and in the process, they lose. They don't see what they lose. Because they always try to take a shortcut. There's another reason why you have to distinguish, because when spouses separate or their marriage is annulled, property which is exclusively owned by one spouse is not divided. What is divided after the payment of all the obligations is only the communal property. So going back to this same example, you have a wife who has exclusive property of 100 million, a husband who has exclusive property of 50, and they own commonly owned properties of 10 or 20 million. The only thing they split up is the 20. They don't split up the 50 because she owns it and she's still alive. They don't split up the 50 because he owns it and he's still alive. The only thing they split up is what is commonly owned. So you have to be careful, because I have had people, some of them lawyers, telling their wives, you know, let's just pretend your father sold it to you. Okay? No more this donation. There's too much hassle. But in the end, the child again loses 50%, 50%, because the husband looks like he owns 50% of the property. Because there is a presumption in law that property acquired during the marriage is presumed to belong to the two of you, unless proven otherwise. And how do you prove otherwise? Your estate tax return, your donor's tax return, those are proof that the property was only meant for you. But if you pretend that another transaction took place, like a sale, then it belongs to the two of you because the law will presume that both of you acquired it using the earnings of the two of you. Now,
Sorry, Vicky, so if it's inherited, then it is...
it depends on what marital regime you are in and when it happened. I will give you, that's why I have dolls here in the front so that it's more illustrative. So, certain obligations are not paid communally. So, for example, there's an illegitimate, which is now called a non-marital child. The support of that child is exclusive only to the person who is the parent. So it's not, the support of the non-marital child is not supposed to be a conjugal thing. Major renovations on separately owned property, losses incurred by gambling only belong to the gambler, but if you win, it belongs to the two of you. Because the law punishes the person who is gambling. But of course, rewards the spouse who is happily beside the gambler when he wins. Now, the first thing is a marriage settlement. A marriage settlement is also known sometimes as a prenup. It's an agreement executed between the future husband and wife, but it must be executed before the marriage, not during and not after. To bind third persons, it should be in a public document, and you register it in the places where the groom and the future groom and future bride have property. Now, even if you don't do registration, it's still binding between the man and the woman because they signed, it's a contract. But to bind like creditors, you must register it in the registry of deeds where there are properties. Because anybody who lends you money and looks at your assets, they should be able to rely on the title. And if there's no annotation of a marriage settlement, then it's not fair to later on tell him, oh, no, that's really not his, that's really all mine. No?
So it will be annotated in the title?
Yes, you annotate in the title that there's a marriage settlement. Frankly, nobody wants to do that, okay? I had to do that for one client one time. She had all these properties and her future husband also had. But when I brought it to the Register of Deeds in Makati, he wasn't satisfied with just the list of what was in Makati. He was demanding a list of all the properties. And since they had extensive properties, they decided not to do it. But at least between the future husband and wife, it's binding. As a general rule, remember I told you there's absolute community, there's conjugal partnership of gains, and complete separation. As a general rule, you can put in your marriage settlement any mutation of that. You can combine. There are different lawyers who write books that say different things. The reason is there are very few cases in the Supreme Court regarding prenups. Very few. Why? Maybe only because very few execute prenups. And second, most of them are too ashamed to sue on a prenup. Now, so as a general principle, you can put everything. As an example, you can put, okay, I'm going to choose, the husband and wife will choose absolute community, but these are excluded. Or we will choose conjugal partnership of gains, but this is also not included. So you can make a mutation. You cannot provide void provisions in a prenup. For example, you cannot say, you can sleep with anybody you want, I'm fine with that, as long as I get to sleep with my dog. Okay? Or something which is normally against public policy. Or, this is where a lot of people make a mistake. You cannot provide that your spouse does not inherit from you. I see prenups that have that, and you cannot. Why? Because Philippine law mandates who will inherit from a deceased person. And the spouse is one of what we call the compulsory heirs. What can happen? It's only when you die that he can say, I don't want it. He cannot say while you're both living, I don't want it. Because there is a prohibition against contracting future inheritance. So if you want your husband not to inherit from you, and you want to put it there, that's a useless provision. Okay, it's a useless provision.
Die with a will. Can you die with
Even with a will, you cannot provide that your husband cannot get, because you cannot provide items which by the law are mandatory. It's like you can say, I don't like my kid, so I'm not going to have that kid inherit anything from me. I once had a woman that came up to me. She was the first one to come up to me was a classmate. So the classmate was talking to me, saying that, her mom wants to see me. She has stuff that she wants to do. Okay, so I said, fine, I'll see her. Then the mother came and she said, I don't want to give any of my children except for one. I want to give my son everything. I said, you can't do that. She goes, but I want. I felt like saying, yeah, but you can't do it. So I told her, you can't, because the law mandates that certain persons have a reserved share. And you cannot, unless for grounds provided by law, you cannot exclude them. Now, if right now, if any of your children get married and you don't have a prenup, what will apply is absolute community. It's the current default or legal system. That is, if you're married from August 3 onwards. So the community assets consists of all the property owned by the spouses at the time of celebration. So if both your parents died and you're single, and then you're going to get married and you don't do a prenup, the minute you say, I do, whatever it is that you inherited becomes 50% owned by your husband. Okay? So that's why it's important. The timing of your death is crucial. It's always better to die after your children are married, because you will see that it belongs only to the person who inherited the property, including the fruits and interest of zero, the other spouse. No? So I'll give you an example of how this works. So okay, so this is the guy, as if you don't know, although he's dressed so groovy. This is the guy, and this is the girl. Okay? Can everybody see my dolls? Okay, so they're not yet married. Let us say this guy, he works very hard. So he worked in London, so he earned a lot of money. Okay? This girl, she doesn't work. Okay? But she comes from a wealthy family. And her grandmother gave her a property or two properties in the Ayala villages. Okay, so she was given two properties. They're not yet married. Huh? Now, this boy also inherited from his father a house. Now, when they say I do, this communal, everything goes into this basket. Without a prenup, everything she owned, everything he owned, becomes owned by both of them. Okay? It becomes owned by both of them. I'm sorry, he's not dead. He's not yet dead pala. Sorry. I meant this is the husband and the wife. Okay? So this is husband and wife. So they now own everything that was owned by the woman and owned by the man. So they're working and working, and they using the money here, okay? They earned, they bought shares of stock, so that belongs to the pool. Now, this girl's grandmother, this is the same girl here. This girl's grandmother decided to give her a factory or the shares of stock in a factory. During her marriage, she got the factory. The factory, the shares of stock in the factory, earned dividends. It belongs only to her, because she inherited it while she was married under the system of absolute community. Now, let us say,
Because she was married during that.
yes, she was married under the system of absolute community, maybe because she didn't do a prenup, or maybe she didn't study the law well. But anyway, as long as she inherited something during the marriage, it only belongs to her, including the income. So let us say her aunt, her favorite aunt, said, I love you so much, you've been helping me so much, I want to give you $10 million. It belongs to her. The 10 million was earning interest, it only belongs to her. So let us say the man dies. Okay, he heard that he was going to die. So let's say the man dies. What is the estate of this man? His estate is made out of half of everything here. I'm going to half it. I might run out of paper lang, but I'm going to half it. So this belongs. She didn't die, so she gets a half. He only owns half of this. I'm going to change the house. I had the house here that's divided into half. So, this is his estate, which is divided among his wife and his children, if he has any. But let's say now the one who died is the woman. If it's the woman who dies, she gets the same half that belongs to her, right? You get that part? And everything she owns separately, which is the factory, the house she got from her aunt, the cash that she had, plus, of course, the half that she owned with her husband. No? This is her estate. So you may wonder, why is it so weird? This was not the default law. But the people who made the law, or made the family code, their assumption was, you're married, you're one. You think like one. And so what they said, that the proper thing is that when you are married, both of you own everything. But what is queer is during your marriage, if one of you inherits or is donated something, it only belongs to you, including the interest. So I don't know if there was a lawmaker who happened to have that particular situation that made it like that, because it's really odd that if you inherit or are donated something during your marriage under absolute community, it only belongs to you, including the interest, which is contrary to what most of us know under the conjugal partnership of gains. So that is the situation under absolute community. So under absolute community, all the property owned by the spouses that at the time you celebrate the marriage, or before you say I do, becomes merged into half by the husband and half by the wife. You know, Saint James the Great in Ayala, Alabang, before asked me to lecture to people who were getting married. And so, I mean, I'm not going to lecture about religion. So I lectured about something like this, the different property regimes. And in the end of the lecture, there were so many people fighting. They would leave the lecture hall and they were arguing about stuff that they have and is this yours, this is mine. So after, I think, maybe about 10 lectures, they stopped asking me because it wasn't conducive to marital harmony. So in this case, it's important to know because like even me, okay? My husband and I work, okay? We don't work for our in-law. We work for our children. So the intent is if we accumulate property, we want to give it to our children. We don't want the other side taking half. Especially if they split up and then he takes half, which is like a double slap in the face. No? You lose 50% of what it is that you're giving to your child, and it's being taken by the one who was cheating on your child. No? Of course, the assumption is it could be a girl or a boy who's cheating. No? But most likely it's a boy, no? Not the girl. So what is important is if your child is getting married, don't give them a gift before they get married. You give them a check dated the day after they get married. And you make any transfers after they get married, especially if they have no prenup. Okay, so just remember, if your kids don't have a prenup and you're going under absolute community, don't give them anything before they marry. And second, if you're going to give them something, document it properly. If it's a donation, pay the donor's tax. I know many people don't want to pay it, but pay it because it's only 6%. Do you want your child to lose 50% of their assets? Pay the 6%. Keep the documents so you can prove that that property only belongs to her because you have a deed of donation and you pay the donor's tax and the deed of donation is clear that it only belongs to that child. Now, so donate after. Yes, Tisa.
When that happens, does the spouse have to sign that document?
No, the deed of donation?
Yes.
No, only the person receiving the donation. But there's also a second angle to it. No? If your parent keeps giving to you, okay, and you don't word it, the deed of donation properly, when the parent dies, all those things that were given to you by way of donation are pulled back into the basket, okay, to the estate. Why? Because the point lang is to equalize. So for example, these are my 3 children, okay? I like Tisa, but I don't like the other 2, okay? So I keep giving her. I give her 10 million, I'll give you 500,000, I give you 1,000. So I just keep giving and giving her. At the end of my life, my estate is so small because I've been giving and giving Tisa. But what does the law say? You gave it to them, you documented it as such, put it back into the basket. So the estate size is increased by the amount I gave Tisa, by the amount I gave her, and the amount I gave Dulce, and then we will divide. So if it looks like Tisa got too much, she will have to equalize, unless I provide in the deed of donation that it's not subject to collation. And that only works if your estate has sufficient to absorb the excess donation. Collation. It's pulling back. It works for descendants. Okay, so if the purpose of that is to equalize. So if you don't like one child and then just keep giving and giving the other, the law says when you die, you pull it back. Let's really divide to see how much each of you are entitled to. Now, all the property acquired during the marriage belongs to the 2 of you under a system of absolute community. So if I work and my husband just plays mahjong, or the other way around, he still owns half of what I earn. Okay? Because the principle is, the two of you are together. It's not all the time that both of you are working. One works, one doesn't work, but the point is you're married. If you are living under absolute community, the earnings of one become the earning also of the other one, even if that other person just plays mahjong. Okay? Now, again, the presumption of law is whatever is acquired during the marriage is presumed to belong to the two of you. That is why you need to keep documents. You need to keep documents, you need to keep assets separate. A lot of people just make oh yeah, we'll just put it there, and they don't document. They don't document donations, they don't document inheritances, because they're trying to save on taxes. So they always not pay the tax, and so there is no proof that something is donated or something is inherited. Now you might ask, what about the titles? If you notice, you look at your titles always say, for example, my husband, his name is Tadeo, so it'll always say, Tadeo married to Maria Victoria. That is only a description, okay? It does not mean that he owns it, okay? The presumption of law is that we both own it, unless I can prove, or unless he can prove that he used his own money to buy that property, because the Register of Deeds will not register a title that does not say your civil status and the person who you're married to. So all of them will say married to. Now sometimes there are some presumptions that say if the girl's name is first, married to the guy, it's only a description, so the girl has to prove, because especially if it was acquired during the marriage, you must prove that you acquired it, and you used your own funds, or you used funds you inherited. And that's the reason why it's important to pay the right tax, because your estate tax returns indicate the properties that you inherited. So for example, you inherited a house in Bel Air, for example, right? That's part of your inheritance. You got it. The estate tax was paid on it. So that only belongs to you. Okay? Now, the title may say my name, married to my husband. When I die, the BIR assumes everything is half hers and half. My children can step up and say, no, this property only belongs to my mom, so 100% of it is included in the estate. You tax 100%, and we will divide 100%. And so the question is, why would you be so happy to tell the BIR that 100% belonging to the dead person, you tax it 100%? Why? Because the person who's the heirs will get more. Otherwise, if you don't say anything, the assumption is half of it belongs to the husband. And then what is divided only is the 50%. Now, if you ever look at an estate tax return, there are 3 columns. It says there, exclusive, capital, paraphernal, total. Conjugal, separate, and total. So the law itself makes a distinction. But the BIR, even if they have handled so many estate taxes, they look at something, across the board, they will half everything. Now, the question is, why will you do that? It's important to know the classification of the property. And that's the reason why you pay the right tax, you document it correctly, and so when let's say you inherit, no, you got that house in Bel Air as an inheritance, okay? So it's worth 500 million, for example. And now you want to sell it. The question is, who owns the money that you get from the exchange of the property, the 500 million you got? Now there are varying, in absolute community, there are some people who opine that the minute you change what you inherited, which is the house in Bel Air, you change it to cash, some people opine that's already communal. Because it's lacking a certain provision which is found in conjugal partnership of gains. But you can also argue it's just an exchange. Why will you deprive me when it's something I inherited? So there's nothing definitive on it. You can just act na lang as if it continues to be yours. Because the commentaries of the different authors are different, no? Now, what are excluded? So the first one, which I discussed already, it has to be something you got for free. In short, you didn't buy it. So it's either donated to you or it is inherited by you. And it must be inherited during the marriage, not before. Because if you inherited it before, then you say, I do, you only own half of it after. So you must inherit or must donate it during your marriage. And that's the reason why I'm telling you, if your children are getting married, don't give them anything before they get married. Give it to them after they get married. And document it and pay the tax. Now, the second one is property for personal and exclusive use of either spouse. And you know, this really refers to stuff like your t-shirt, your underwear, but it does not include jewelry, because the assumption is the jewelry is expensive, no? Of course, if it's costume jewelry, nobody wants it also, so it belongs to the person who's using it. And then the third one is if there was property acquired before the marriage by a spouse who has legitimate descendants from his previous marriage. For example, I'm married to husband number one. We acquired properties. My husband dies. I inherit properties from him. No? I inherit properties from him. Now I'm going to get married. If I don't make a prenup, are the properties I own now part of the community? The answer is no, because as long as I have legitimate descendants from a previous marriage, that is separated. It does not mean that only your children from the first marriage will inherit it. No, it doesn't mean that. It just means it's not commingled with the second marriage. Because when you die, everything goes into a pot and you divide it in accordance with the laws. The fourth one is certain properties which are only supposed to be owned by Philippine citizens, like land. Okay? There's so many foreigners who are told incorrectly, let's buy a house, put it in my name, and them not knowing, or even if they know, they put it, they're not allowed to own land. Land, I'm not talking about the condo unit. They're not allowed to own land. And so they cannot say later on when they split up with their wife, I really paid for that property. That really belongs to me. Because the law says you knew it was illegal. You cannot profit from that. So that's one of the examples of property which is excluded. You don't need the signature or consent of a foreign spouse on the sale of a property or the purchase of a property, because only the Filipino citizen can purchase it. Now, going to the second one, this is the one that most of the older people know. So let's go back to our example of the dolls. This is the conjugal partnership of gains. The essential word here is gain. It's only the gain which is owned by the two of you. So we have here again a man and a woman. They're not yet married. During their when they were still single, the woman inherited a factory. She inherited cash. The man inherited a house. And then they got married. You notice there's no movement. They still each own what they own. She earns money from the dividends from the shares of the company. The dividends belong to the two of them. He rents the house and he earns income the income belongs to the two of them. It's a gain. But the house still belongs to him. And the factory shares still belong to him. So, when they say I do, after, it's only the gain. So the two of them work together. They're able to buy a lot using their salaries. It belongs to the two of them. They rented the lot. It belongs to the two of them. She sold the factory and she got cash. The cash only belongs to her. It's a replacement of her factory. She earns income on the cash that she got from the sale of the factory. The income belongs to the two of them. So the term is gain. So whatever you own before you marry belongs to you. Whatever you inherit before, during the marriage belongs to you. But any income earned by what belongs to you belongs to the two of you. Okay, this is the one we all are more comfortable with, which the code changed. So if you were married prior to August 3, 1988, and you didn't do a prenup, this is the system that you will get. To continue, the guy's father gave him a house while they were married, donated the house to him. The house only belongs to him. He rented the house. The income belongs to the two. So the crux of the word is gain. It's only the gain which is owned by the two of them, including whatever they worked during the time they're married, or whatever they exchange, what they own here. If he sells it and gets cash, the cash only belongs to him because he's only exchanging what he owned exclusively. Do you understand? Okay, now, what are the assets which form the conjugal partnership of gains? Assets acquired during the marriage using common funds. So while you're married, both of you earn, both of you decide to buy a house. That house comes from your common funds. They belong to both of you. Assets obtained from the labor, work, or industry of either or both spouses. Like I said, it could be that the husband's the only one working. The woman stays at home to take care of the children. The asset still belongs 50-50 to the two of them. The fruits, industrial or civil, during the marriage from the common fund. So if the two of them earn salary, they put it in the bank, or even if only one of them earns salary, puts it in the bank, the interest earned on that belongs to the two of them. Okay? Now, the share of either spouse in hidden treasure, okay, that's one of the rare ones. Let's skip that. Then the other one is livestock. Okay, that's for, these are the old provisions of the code. And those which are acquired by chance, such as winnings, again, if you lose, that's yours. The losses are yours, but the gains belong to the two of you. Now, there's an exception. Let us say I own a lot in my name only. Okay, I'm the only one who owns it. And then the family decides to build a big house on it. The funds to construct this house comes from the two of you. And the value of this house, at the time it's constructed, costs more than the value of the lot. What happens is the lot gets converted into conjugal. But it's converted to conjugal. There is payment to be made, but the payment only takes place when the marriage is ended, which means when one of you dies in all likelihood, right? I don't know why they only pay them when somebody dies or the marriage is ended. They should pay them ahead. But that is one of the exceptions where if you own the lot and the two of you built something on it, the value of which costs more than the value of the lot, it gets converted into conjugal. So be careful. I had a client like that. So I warned her about it because she kept improving and improving. And I warned her, that's only yours because you inherited it. But if you keep adding and adding there, it could be that the value that you put in will convert the property, right? So after a while, she started noting how much was spent on it. Because you really have to, well, some people don't care, no? But it's always better to document things properly, no? So what are excluded from the conjugal partnership of gains? Assets owned by either the bride or groom, like they inherited it prior to their marriage, that still belongs to them. Unlike absolute community, the minute you say I do, it gets split into two. But in conjugal partnership of gains, whatever you got for free, that means by way of donation, by inheritance, before or during the marriage, only belongs to you. It is only the income from these assets that belong to the two of you. Assets donated or inherited prior to or during the marriage. Assets acquired by right of redemption or barter. So if I own something, I inherited something, and I sold it, the cash which I get in exchange still belongs to me. But that is why it is important to document. Do not start merging your, okay, I got 20 million today, I'm going to deposit in a joint account. No, keep it in a separate account and make sure you can track where it comes from. And then assets you purchase, so for example, you inherited 20 million from your parents and you're going to buy an apartment, you make sure that it's clear that you are using what you inherited to purchase the apartment, so it is clear the apartment only belongs to you. Normally, when I document things like that for my clients, I always put there, using exclusive paraphernal properties or exclusive capital properties, the buyer is buying so and so. I mean, for whatever it's worth, you just put everything there, no? Now, there's the third one, which is the one that's least conducive to a happy marriage. It's where everybody says, okay, what's yours is yours, what's mine is mine. And the contribution to the house will just contribute proportionately. I don't know if you ever saw that movie with the Chinese. It was an American movie where a Chinese couple living in America, they obviously had complete separation of property. I forgot the name of the movie. It was a very famous movie. So one day, the husband comes back from the supermarket, and he starts laying out the groceries. So he says, okay, this shampoo, you're going to use half of it, so you owe me half of the shampoo. And then this one, this is my deodorant, okay, that's my column. So you could see that that's what it ends up being. But there are some people who are not so strict. They just do that practically for family, when the family tells them, make sure that you separate. But what happens here is, what is yours, what is mine. We contribute to the expenses. This one has to be in a prenup, no? We contribute to the expenses. You can contribute 70%, I'll contribute 30%. So you can stipulate. But in this regime, there is no mingling unless you provide in the prenup for certain exceptions. Now, in complete separation, each spouse owns, disposes, possesses, enjoy his or her separate estate without the need of consent. All the earnings from profession, industry, and all are deemed only owned by the person who earned it. Both spouses shall bear the family expenses in proportion to their income. So, the conclusion of this talk is, the characterization of property as being communally, conjugally, or exclusively owned has enormous financial repercussions, not only on yourself, but on your children should you die. Like I gave you an example of what happens. Now, in the past, the tax rate applied to transfers of property before 2018, January, was 6% for capital gains, maximum of 15% for donations exceeding 10, and 25% for estates exceeding 20. But now everything is 6%. For your information, I understand that there is a bill to raise everything to 10. 10 equally for donations, for inheritance, and for a sale of a capital asset. There's a draft bill. I was trying to look for it. Somebody just mentioned to me, heads up. I'm not sure if it was, I don't know if I recall correctly, if it was recto, but he said that there was a move to raise to 10%. Now, even at 6 is a very low figure, okay? Compared to 20, but Filipinos still don't want to pay the 6%. So, pay the 6%. It's going to become 10 soon. Now, with the new train law, transfers by sale of capital assets, by donations, or by death are taxed at a flat rate of 6%. So there's no reason not to transfer properties to your children to reflect the correct intention that you want it to be a gift. Now the question is, why would people pretend it's a sale if the tax is the same? That can be used. Let's say she's my favorite daughter, okay? Now, every time I give to her, obviously, when I die, that's all going to be pulled back, and she's going to have to cough up the differential, right? So what I say is, I'll sell it to you. On the assumption she has money to buy it, it'll look like she bought it, and so it's not subject to a pullback. If she's my favorite. Now, of course, that's something you shouldn't do because it's not honest. But I'm just telling you, that's what people can use it for, no? Not that you have to use it, but I have had clients that couldn't stand some of their children. They really hate some of their children, no? So there's different ways to go around it. One of them is to change the citizenship of the person who is the parent. You become an American because they have leeway. But if you're a Filipino, you're forced to follow the way the law divides the estate, no? So, in short, right now, if you're going to give anything to your children, first find out if they're married or not. Of course, you would know that, right? And then if they're married, or not yet married, then you have to think 10 steps ahead. Okay, I have 4 children, none of whom are married, okay? So every year I donate. My husband and I donate. Why? Because under the law, there's a freebie of 250,000 per person. Of course, it's so pipichugin, it's not gonna get you anywhere, but if you start from when they're small, that'll be a lot of free money that you're not taxed, right? So I always put in the deeds of donation that anything we donate to them has to stay exclusive property. Otherwise, the donation can be revoked. Now, some of you will be embarrassed to ask, you know, like let's say if your kid's getting married, you tell your kid, oh, you do a prenup, but your kid's too ashamed to ask for a prenup. So you tell them, okay, if you don't do a prenup, you donate. Of course, it's very expensive. You donate it back to me, and I'll wait until you're married and donate it back to you. It's a very expensive exercise, no? Because you're taxed. Aside from the first donation, you'll be taxed 2 more times, no? But that's one way to go around it if they don't want to execute a prenup. So basically, that's the lecture. So I'm happy to take questions, assuming I can answer them. So does anybody have any questions? Or you're bored already and want to go home? Yeah.
So, in the Philippines, does it benefit his inheritance, or can you go around the inheritance law by creating trusts or foundations?
Okay. Now, let's answer the question first on trusts. In order for it to get out of your estate, the trust must be irrevocable, which means you must pay the tax. Because it's not like the US, okay? The US, you can create a trust. But for some reason, a lot of people think they don't need to pay the tax. If the trust is revocable, it's still owned by the person who died. Except that it tells you how it's supposed to flow. That's how the US trust thing works, right? In here, you can create a trust, but you have to pay the donor's tax to make it an irrevocable trust. Now, let's say you don't. You still make a trust, and you provide who gets what. You didn't pay the donor's tax. So when that person dies, the bank technically is supposed to include it in the estate, except that they will follow your instructions on how it is to be disposed, and provided it does not go contrary to the laws on the division of an estate. Yeah, because here we're very strict about preserving the share of the heirs. No? In the States, you can wipe out all of your children by making a will saying that it's going to go to your dog, okay? Or it's going to go to your best friend. So here, even if you make a will, it's the law that is the first thing that must be kept in mind. So when you make a will, it still has to comply with the provisions of law in the Philippines on who gets what and how much. Any other questions? No more questions? Yes.
Does it get complicated if you're married to a foreigner and you have other assets abroad? Does that fall under Philippines?
It depends who dies. Okay? So if the person who dies is from the UK, it is his law that determines who gets what. Okay? So if his law permits him to wipe out all of his relatives and to give it to charity, then it is his law that is applied. Not the law of the Filipina who is not the dead person. It is the law of the dead person. So under our law, it is your nationality law which determines the way, the succession, the rules of succession, the division, etc. So if you are the one who dies and you're Filipino, then it is the rules of the Philippines which will apply to you. But if the one who dies is a foreigner, it is the rules of his country on succession, the order and the amount of successional rights, which will determine what you get as an heir of a foreigner.
What about international properties? How does that apply to the Philippines?
In the Philippines, we're like the US. It's anywhere and everywhere. So everything goes into the pool. Now, the assumption, of course, of most Filipinos is they don't know it's there. So they won't know. But you have to remember, we are moving towards common reporting standards, which is like the FATCA, but it is for the rest of the world. So if you're hiding assets, for example, in let's say in Singapore, we haven't signed the CRS. There's no implementing law, but Duterte signed the CRS agreement. And we have to comply with it because it will be like the anti-money laundering. If we don't comply with it, they will, in a few years, assess all our banks for transactions that are done abroad. They will penalize them. So looking forward, you have to assume that what you own abroad may be found out, because the way the CRS works, once it's implemented, if you have a bank account, for example, in Switzerland, or let's say France, and they determine from the answers to a certification that you're not really a French citizen, but a citizen of the Philippines, they will then send the information to the French IRS, and the French IRS will send it to the BIR. So you always have to assume now that everything's moving forward, because I have a lot of questions. People, yeah, but they don't know. Yeah, they don't know today. But they may know in 2 or 3 days or by the time you die, no? But normally, before the CRS is implemented, they will do an amnesty. That's happened to all the countries. Before they move into the common reporting standards where there's reporting all over the place, they will give an opportunity for the citizens to come clean. So when that comes about, then you know that the CRS is there. Besides, we already have a pilot project with Australia where they're testing how to find out how much money and where it's located. Any other questions?
What if you're a dual citizen? What does one country override the other country?
There is a tax crediting. There is tax crediting. So for example, in some countries, your assets, if you're, let's say, a citizen of Spain, it's only the assets that are located there. But if you're a citizen also of the Philippines, it's anywhere and everywhere, so we include the one of Spain. And Spain may not necessarily include the ones in the Philippines because you're not resident in Spain. But if you pay tax, you can ask for a tax credit. But of course, you know how it is to ask money back from the BIR. It's just better not to try. Does anybody have any other question? So I hope you understand how important it is to take care that you document your assets with the right classification, not necessarily naman because you want to be, what's that term, you're counting. It's not because of that. It's so that you can pass it on properly, and then when you die, your children will get the proper share. So that's it. I guess you don't have so much questions. I hope I was clear enough that you didn't have questions or it was over your head already. Thank you.